I've spoken frequently about relief from sanctions, and I'm going to speak about it yet again. And that's because there have been two recent decisions of importance. The first is a case called Gladwin and Begescu, a decision of Mr. Justice Turner. And the critical thing to come out of this case, which is sometimes overlooked, is that if you are guilty of failing to comply with an order, a rule, a direction, the court can strike out the guilty party. And that is what happened in Gladwin. It was all down, said the judge, to the claimant solicitors. They had lamentably failed to produce their witness statements on time. And so when the case got to trial, instead of the trial taking place, we have arguments about whether relief should be granted, whether the late statements should be admitted. Well, they were admitted, but that was overturned on appeal by Mr. Justice Turner, who said it was a colossal waste of time and it was all down to the solicitors, and the right thing, brutally, was to strike out the claimant's claim. Now, that, I hasten to add, of course, doesn't mean that it's all over for the claimant, because naturally the claimant will have the opportunity now of turning upon the solicitor and saying, it's all your fault, it's your professional negligence, I want my money from you, because you've denied me the opportunity of recovering from the defendant. Now, it's rather sad actually that the matter was struck out, because cross-examination, I suspect, would have been rather exciting in this case. The claimant alleged that because of his injuries in a road accident, he was in a pretty bad way. The defendants, meanwhile, had discovered that despite being in a bad way, the claimant had won a silver medal in a judo competition. So you can see that there had been fun and games at trial. And maybe, just maybe, that factor influenced the judge in deciding to strike the lot out. But do appreciate that it's not necessarily a matter of do I get relief or not. It could be worse. It could be the matter, or the defence, as the case may be, is struck out. The other authority, a case called Lakhani and Mahmood, remarkable because relief was refused where a budget was filed 1 day late. Now, oddly, there is no mention in this appeal judgment of the fact that in the infamous Mitchell case, the defendant had filed their budget 1 day late. But in the Court of Appeal, at the hearing, Lord Justice Elias said, 1 day, negligible, de minimis, forgive. But not in this case. Now, it's always important to latch on to the detail. The defendants got into an argument about whether they should even have filed a budget. Were they obliged to file a budget? So time was wasted there. And there was a failure to make an immediate application for relief. Over and over again, the day you ever spot a default is the day you make application for relief under Part 3.9. So that counted against them. All this in the backdrop of Christmas and delays there. It was a bit harsh because the defendant who failed to file the budget, it wasn't their choice that Christmas Day should fall on the 25th of December, but it did cause disruption. And with that, the judge backing the first instance decision held that it was right to refuse relief. Now, obviously, the defendant is entitled to defend. They can carry on with their defence. But the sanction, Rule 314, if you don't file a budget and you don't get relief, you are treated as having filed a budget claiming court fees only. So both of those cases, I think, demonstrating, both 2017 authorities demonstrating a tougher, harsher line being taken on default. No one should think that the Court of Appeal's decision in Denton was meant to go back to the old days when people could breach rules with impunity and always almost get away with it. So be careful.